For the next panel, I'm going to hand it to Maura, who is our editor-in-chief, so in a sense, the maestro behind the project. Maura, I can't see you right now. Yes, I can. All right. So everyone is on. The floor is yours.
Hi, everyone. Thank you so much for attending this conference. Thank you to our panelists for being here today. And of course, to the computational antitrust team, and of course, Thibaut for bringing us together. I'm here today to introduce our panelists for this session. We have Ron Schnell, who is a computer science expert with more than 40 years of experience in the high-tech industry and in academia. He was the general manager and chief executive of the technical committee, the organization that monitored Microsoft under the final judgments in United States versus Microsoft. And he is currently a director at Berkeley Research Group and adjunct professor of computer science at Nova Southeastern University. We also have Doug Melamed, who's professor of the practice of law at Stanford Law School. Before entering academia, he served as senior vice president and general counsel of the Intel Corporation, chair of the Antitrust and Competition Practice Group at WilmerHale, and acting assistant attorney general in charge of the Antitrust Division at the US Department of Justice. So for the next 20 minutes, I'll turn over the floor to Ron, who will present his paper, Antitrust Enforcement in Big Tech after the remedy is ordered.
Thank you. It's great to be here. I prepared some slides. I don't know how those are going to show up. Thibaut?
So we will promote you. Yes, you've been promoted. So you can just share your screen.
Okay, great. Sorry, I thought that maybe they would.
I've seen the slides, so I know they look fantastic.
Great. Okay, just a moment. Sorry.
Do you want me to share the slides?
I'm doing it, I think. Okay, can everyone see this?
Yes.
Okay, all right, so I'm going to be talking about something a little bit different. This is how we use computation after there have been remedies assigned in a case. So in a lot of ways, it's a lot easier. In some ways, it's a lot harder, but what we're looking at in terms of data and such is a lot better defined, I would say. So the paper I'm talking about is called Antitrust Enforcement in Big Tech After the Remedy is Ordered. I have two co-authors. One is Jay Himes, who at the time of the Microsoft case was a deputy attorney general of the state of New York. So there are actually two cases, right? There was the New York et al. Versus Microsoft and the US versus Microsoft. So he was really one of the main people in the New York et al. Versus Microsoft matter. Jason Nee, who had some involvement prior to the remedy, but in this paper, he talks about a different case, the Bizarre Voice case. And then there's me. I'll give a little bit of background, additional background about myself. I started out as a hardcore programmer working at Bell Labs, Sun Microsystems, and IBM, all on the kernel of their version of the Unix operating system. So all of those three things were in direct competition with Microsoft Windows, which some people would say is not a coincidence. I also lectured at NYU when I was 14. I was also a researcher at the MIT Artificial Intelligence Lab. After that, I had three startups, the last of which I sold to a public company in 2000. I retired after that for a while, ended up helping out a friend and becoming a vice president at Equifax Corporation, one of the three credit bureaus in the United States. And I was about to do another startup when I got this strange call asking me if I'd be interested in working on this monitorship. And I jumped at the idea. It sounded like a really cool project. So it all has to do with the two final judgments in those two matters. The judgments changed or got modified a couple times, but it was originally entered in November of 2012. And one of the things those judgments said was there was to be an appointment of a technical committee. So this was very unusual at the time. Even to, I mean, typically, I think back then, even it would be a special master or a retired judge who would do the monitorship. There wasn't as much of a concept of having a technical person involved in the monitorship of an enforcement action. But it said right in the final judgments that the TC technical committee members should be experts in software design and programming. So that was somewhat unique at the time, and it was sort of, you know, later on it would be seen as a great achievement, and the judge was very pleased with it, as you'll see. So what happened was the way that the technical committee was formed was that the Department of Justice and New York and the group of states would choose one person. Microsoft would choose a second person, and the two of them jointly would choose a third person. So the DOJ in New York and et al. Chose Dr. Harry Saul, who's a very well-known computer scientist and a very successful entrepreneur. He started Network General, and that was a really big thinker in high tech. Microsoft submitted Franklin Fite, who was an executive, a former executive at Microsoft, who since retired, and also a great technology thinker. And the two of them together submitted Dr. Skip Stritter, who was an entrepreneur, founder of MIPS Corporation, one of the early employees of Apple, and another very well-known technologist. So they were called the members of the technical committee, capital M members. And, you know, I think I know that it was envisioned at the start that these three guys would, you know, look at what Microsoft's doing during the remedy phase and be able to monitor them on their own and sort of make recommendations and allow Microsoft the ability to cure any issues if they came up. But, you know, they knew right away that was not going to be enough, that they were going to need more people, they were going to need more resources. I mean, Microsoft at the time, I think, was an 80,000 employee company, you know, at least half of it having to do with Microsoft Windows and things that were directly related to the final judgments in these cases. So they created a corporation called the TC that was actually going to carry out the monitorship. And, you know, so the TC, in a sense, is separate from what's defined in the final judgments as technical committee, but they're really used interchangeably. And if you look at court transcripts and press articles about our organization, because eventually I was brought on to run the day-to-day operations of the TC. So, and the final judgments actually consider the hiring of staff and consultants by the technical committee. I don't think the people who wrote the final judgments thought about forming a corporation, or what eventually ended up being me hiring 93 people over 6.5 years, because the final judgments did get extended several times. So there are several sections of the final judgments that had to do with enforcement. I think the one that I started out with, the one that's most well known by the public, and that was section 3H. And 3H talks about a bunch of things, but the two most well-known things, and probably two most important things in 3H, were the ability of consumers to choose default programs. So at the time, you know, the complainants in the case were people like Netscape, you know, for Netscape Navigator, and Real Media, you know, media players and things like that. And their complaints had to do with the fact that Windows really gave a lot extra ability for people to use their, you know, the Microsoft products as opposed to third-party products, and really made it difficult, they claimed, for them to be able to get customers. So that was the first thing, to allow users to have default programs. And the second thing was to allow users to disable Microsoft's programs so that they wouldn't even show up as icons and things like that. So that was section 3H. And it uses the term Microsoft middleware, which is, in computer science, we would look at this definition and say, well, that's not middleware, but this is what the lawyers termed as middleware. So for 6.5 years, this is what I called middleware. So it was, things like programs that provided the functionality of Internet Explorer, Microsoft's Java Virtual Machine, Windows Media Player, Windows Messenger, Outlook, and their successors, or just generally speaking, in case there are other things that don't have these names, internet browsers, email client software, networked audio video client software, instant messaging software, et cetera. So those were the things that we got to focus on at the technical committee and the TC to figure out what we were monitoring exactly. So how do you ensure compliance, right? And eventually, how do you ensure it computationally? Because we were all technologists at the TC. That was the whole point. So what we decided, what we thought we could do, was we could use test scripts to ensure compliance with these provisions. Because it's so well defined in the final judgments, we can check to see, for example, if we if a user were to try to set a default browser to this new browser, would it work? And this is very straightforward. You can do this without human intervention, right? I mean, we're simulating human intervention, but it's not really human intervention. And we had to run these test scripts regularly because Microsoft Windows changed regularly, and the potential middleware changed regularly. So we could run these test scripts automatically on every release of a new version of Microsoft Windows, on every release of the regular operating system updates that were part of Windows Update. Or if there had been complaints from third-party middleware developers, we could run the tests again related to that. And also these scripts, these programs could be updated based on all the feedback loop from their execution, from potential complaints or anything like that. So really 3H would be quite simple to programmatically test. In addition to human intervention, we also could do a lot of that as well. I have to be a little bit careful about what I say because the protective order is, what amounts to a lifetime gag order for me that, for anything that's not public information, so I limit what I say to what's in public record. So that was 3H, and 3H, like I said, is what most people knew about and what most people talked about. But what not a lot of people knew about, unless they enjoy reading court transcripts and stuff like that, was section 3E. And the supermajority of the work that we did was related to section 3E. I had over 40 people at a time working on just the insurance of compliance with section 3E. And what section 3E said in both final judgments is that Microsoft was required in great detail to document all of their proprietary communications protocols that would work from Windows Client to Windows Server and vice versa. And I believe the reason for this was so that a third-party vendor could create these protocol elements on a server, so that they were compatible with the monopoly of Windows clients out there. So it's sort of, if you can't compete on the client side, perhaps it's easier to compete on the server side. And by documenting all the protocols, somebody could do that, right? So this ends up being a really daunting task, right? So it ends up being an astounding number of protocols. Windows has been around for a long time. The final judgments was not specific about which protocols needed to be documented. So that meant that protocols needed to be documented that hadn't been used in decades. And it was difficult for Microsoft, especially, they had a great history of creating a lot of wealth and a lot of retirees. And for some protocols, there was no one left at Microsoft who even remembered not what they did, but certainly how they were implemented down to the bit level. So it ended up being tens of thousands of pages. Microsoft's first release of what's called the protocol documentation, or the MCPP, Microsoft's Communications Protocol program documents. So that's a lot of documents. And what we needed to do, as Microsoft called us regulators, actually, was we needed to figure out how to verify the accuracy and completeness of all of those tens of thousands of pages. So that's obviously a really difficult job to do. And we, again, tried to figure out how to do it computationally, because that's what we were good at. We were all technical people, but it was an enormous scale. So we also realized that reading technical documents is not something that lawyers or judges could do. So we leveraged our ability as technical experts to just do desk reading. I mean, we could actually try to verify as best as possible the accuracy of these documents by reading them and looking for obvious errors. Keep in mind that since we're talking about communications protocols here, one bit being off could be it would make it unusable, right? You might not be able, you wouldn't know, as someone who's developing these protocol elements, what is causing an error. You're going to get an error. It's not going to be compatible with a monopoly of Windows clients out there, and you're not going to realize that it's one bit wrong in these tens of thousands of pages of documentation, or at least the subset for this protocol, without a lot of work and a lot of trial and error. So that's something that we thought was really important, that we catch as best as possible. So sometimes desk reading could catch stuff like that, but at scale, obviously, it doesn't work. Although I would say you'd be surprised at the amount of stuff we were able to find from desk reading. So, but what really the most of our effort was something called the Protocol Project. So basically what we did, and this goes to a question in the last talk about simulation, was we pretended to be third-party protocol developers. And we, on Linux boxes, we wrote code solely by reference to the MCPP documentation to be a server for these protocols. So, and we did it, very modularly, protocol by protocol. And we wrote a ton of code that we later threw away that looked at this documentation and did things like SMB. We did things like netlogon and all of the Windows protocols. And if something didn't work, our work product was a bug report against the documentation, which Microsoft would then fix. So those two things were really what we did to ensure accuracy as best we could. We had another project, because we scratched our heads for a while trying to figure out how are we going to verify completeness, because if something's missing, if a protocol is missing, if a portion of protocol is missing, a certain endpoint to an API, how would we know? We couldn't do that using desk reading or the protocol project. So what we decided to do with Microsoft's help was actually instrument Microsoft's test labs around the world. We actually got some at the time really state-of-the-art hardware that we installed in Microsoft's test labs, and we captured all of their network traffic at wire speed, which was very fast and a lot of traffic. So we were using, petabytes of disk space, in the 2000, the mid 2000 to late 2000 time frame, and then we turned the protocol documentation from unstructured data to structured data using XML markup. And we programmatically compared what we captured in the network with the documentation. And that was our endeavor to figure out the completeness aspect of the documentation. That was for me, a really, really cool project, and it was very interesting. So the output of all of these things, as I mentioned, was bug reports on the documentation. We called those, and the court called those TDIs, technical documentation issues. So that's what we did for 6.5 years, is we created TDIs that Microsoft would receive and fix. So we produced tens of thousands of TDIs. It was a crazy number. Because it's like I said, it's a tough project to create this documentation. And we had to hire more and more TC staff. As I mentioned, in total, we hired 93 people because we had to scale this thing, because it was just so much work. And eventually, some of the documentation we started to suggest fixes to Microsoft, which they pretty much adopted. Microsoft talks in their court filings about the fact that they hired more and more staff to handle our TDIs. At one point, they mentioned that they had brought 800 people onto the project. So it's not. I can't talk about how they define a staff member in that context, but that certainly they had a lot of people working on it, and they definitely took it seriously at most of the time. And keep in mind that the European Commission was also running a similar type of action. And eventually, at one point, the European Commission was fining Microsoft, I think, €1 million per month, I think, until certain documentation issues were fixed. And of course, those documentation issues were the same ones that we were filing. So in terms of what the court had to say, I'm very proud of how the court reacted to the work we did. There were times when Judge Keller Catelli was a little bit frustrated with the rate of TDI fixes. She says in this particular excerpt, she talks about, at first she thought that Microsoft was going to be doing all the work and we would just be monitoring it. And she says here, I will just throw this out. I don't have a full understanding. I do appreciate the fact that these are not simple, that these are complex. But I think it's interesting that it appears that the TC is able to do what is necessary and bring Microsoft along, not the other way around. So this was, kind of an astounding thing for a judge to say in open court. And it was really, like I said, I'm very proud. I was very proud of it. I'm sure Microsoft wasn't happy with that comment, but I was proud because we were doing great work, and we were happy to be picking up some of the stuff that Microsoft didn't have the resources to do or whatever. But it was such a cool technical project. I mean, most of the people who worked for me loved doing these simulations, doing the structured data analysis and stuff like that. And I actually, because I still program, I started out as a programmer and I'm still a programmer at heart. So I took on some of these protocols myself. So there were several of them, and Microsoft didn't know which ones I was filing the TDIs on, but it was really fun, and we had a lot of pride in our work. And some people had an issue with the fact that they did all this really cool work and then we had to destroy it because that was the way it worked. But at the end of the case, a bunch of staff people and I went to a giant shredder in I believe it was in San Diego or Orange County, California. This is like one of these shredders you can throw a Volkswagen into and it'll shred it into little pieces. And we literally took all of our stuff and threw it into the shredder and watched it all get destroyed. So in a way that was sad, but we still had a good sense of accomplishment. So in terms of computational antitrust in the future, I think it's important, even though our paper is titled, high tech it's not limited to high-tech defendants, right? I mean, there might be a misconception about that, but really every company has some high-tech element to them. I mean, they have an online presence. Remedies often include restrictions and requirements related to that online presence, like online advertising restrictions, network safety and security restrictions, communications requirements, things like that, website layout, content requirements. Doesn't have to be a high-tech company to have this in the remedy for a case, right? And all of these things are very ripe for computational monitoring. It's very, there are libraries all over the place that do things like screen scraping, collect data and analyze them, and all of these things can be done that way. I've seen a bunch of cases recently in the antitrust area that have to do with, limitations on search rankings and things like that, and all of that stuff is easily checked computationally. Obviously, we just heard a great talk about machine learning and artificial intelligence, and some of the issues with that, and some of the usefulness of that. I think for the remedy phase, it's much easier, right? I mean, we're lucky if we're looking at remedies, because we're very limited. We're grabbing the data. It's very directed. We can grab that data. We can sort of learn. We can use machine learning and come up with a computational algorithm to look for something that's well defined in a final judgment. So I think it's an even more compelling place to use artificial intelligence and machine learning. And in some sense, we did that with the wire capture part of our project. So I think that's all I've got. So I will open it up to Laura.
Sure. Thank you so much, Ron. That was a fascinating look at the remedy aspect of the antitrust enforcement process. I'll turn it over to Doug at this point for 10 minutes of comment.
Thanks, Laura. This is a really interesting paper, and it's a very important topic, of course. Taking a careful look at the problems of implementing and ensuring compliance with antitrust remedies in this increasingly complicated world in the technology industry, and I take Ron's point, not just the technology industry. Ron said he was very proud of the comments that he got from the judge. He certainly should be proud, not only of the work that the technology team obviously did in that case, but of the quality of this paper and its transmission of the learnings to us. I'm going to spend a few minutes with some comments from the perspective of a lawyer. I'm not a technologist, and I'm going to focus on a couple of things I take away from the paper, and a couple of thoughts that maybe are implicitly followed with the question. So I'm going to start with the paper starts, the purposes of antitrust remedies. The paper correctly lists 3 purposes of injunctive relief. It omits, because I guess it wasn't the subject of the paper, 2 other purposes served by antitrust remedies, and served in particular by monetary remedies, and those are compensation and deterrence. And I'll come back to that later. Among the remedies for the purposes for injunctive remedies, there are 3, as the paper notes. 1 is cessation of unlawful conduct. That's pretty straightforward. It flows from the liability theory of the case, because the plaintiff has to identify what is it that the defendant did that was wrongful, and they don't do that again. It's not doing it. The second is a little dicier, preventing a recurrence. Now, you could say don't do it again, but the problem with preventing a recurrence is it raises the question of at what level of generality or abstraction do you define the violation. So in the Microsoft case, for example, was it harm to browsers? Was it harm to all desktop middleware? Was it harm to all middleware? Was it harm to all complements to the operating system, and so on? And that's a legal question that the court has to determine. But again, what's that question, which is really the question of what's the violation, what's the liability theory here? the remedy follows directly from that. The hard question on which Ron Nichols' focus is the third purpose for an injunctive remedy, and that is restoring to the market competition that was lost because of the illegal conduct. And that's an inherently very difficult task because it requires defining and at least roughly measuring the harm and then figuring out what to do about it. And that's hard in complex technology industries. So, against this background, this excellent paper is about the difficulty in ensuring compliance with complicated restorative injunctive remedies. And it does a terrific job at summarizing some of the learnings from that Microsoft and other experiences. But I want to suggest that some of the learnings might go beyond the question of how to improve compliance with the decree. Here's some of what I took away from the paper. One, the remedy is not likely to be in the defendant's interest or the interest of its employees. If it had been, they probably wouldn't have needed a remedy to get there. So they're not going to be eager to comply. Two, the defendant has a big informational advantage compared to the plaintiff in the court and even compared to the technology committee when it starts. And one consequence, which is noted in the paper, is that the remedy is likely to be imprecise in important respects. And thus, in compliance and certainly the issues of defendant's good faith might be hard to assess. Third, the remedy is not likely to be on the defendant's ordinary business path. So even the defendant is likely to find compliance more difficult than anticipated because it did not foresee all that the remedy would require. And one consequence of this is noted in the paper is that compliance, at least in those cases, and presumably others in the future, will take longer to achieve than initially expected and maybe won't. Fourth, both the defendant's compliance effort and the ability of the plaintiff in the court to assess compliance will depend heavily on the technical competence and resources of the monitor. And fifth, there are going to be disagreements about the meaning of the decree. And here I agree with the suggestion in the paper that doubt should be resolved in favor of the plaintiff because the defendant had better knowledge when the decree was entered, and we want to create incentives for the defendant to share its knowledge at that time and help him to articulate a sense of the decree. Okay. So I came away from the paper thinking these are tough problems. And their problems is Ron knows, as lawyers will be not well suited. And I completely agree with the suggestion that the plaintiff of the court should have finding or other authority to impose non-compliance penalties. And I would add that I think it should be pretty much a no-fault standard. The defendant agreed he had better information about feasibility, so he ought to be expected to comply, period. No excuses for that. And I agree with the suggestion that there should be periodic progress. But I think there are two implications that I take. One, if the remedy takes a long time to implement, and if it takes longer to implement than maybe the parties hoped that the court ordered initially, there's always the question of whether it's going to do much good in the market or whether you can be shooting behind the back. Are we going to have some improvement with respect to access to middleware so many years after the case was filed or the case was decided that by that time it's not a meaningful curative to whatever damage was done by the unlawful conduct. And second, there's a danger, maybe the likelihood that the monitor becomes a regulator. Because it's, as the judge noted, so much of the work, heavy lifting, can be done by the monitor, and it was evolving, and they were interpreting ambiguous provisions of the decree. At some point, becomes a regulator. At least to an antitrust lawyer, that's kind of not a red flag, certainly much. So I wonder whether computational monitoring, as it were, can be used not just to help us understand how to comply with decrees, but to help us understand the efficacy of decrees. And by that, I mean not just did Microsoft wind up doing what it was supposed to do, but did the decree wind up restoring the competition that was damaged. So maybe plaintiffs and the courts, because of among other things of their information asymmetry, disadvantage compared to the defendants, don't really know how to restore competition to technology. For the same reason that they have difficulty specifying the details of the decree. So maybe injunctive remedies will always shoot behind the duck or far afield from the duck because of those information asymmetries. And of course, we have to worry about cost of compliance. So putting all this together, and these are the thoughts that are followed by a question. I wonder whether some or all of the following makes sense. We should rely more on damage remedies and perhaps newly created, hopefully to be created, finding capacity by the U.S. agencies to deter antitrust violations, so we have less need for injunctive remedies. And to base, and if we do that, to base monetary remedies on basically on harm to plaintiffs, like our damage remedies is suboptimal because, as we all know, customers and suppliers, the remedies compensate only the inframarginal, not the deadweight loss, and they're similar. Compensatory remedies are similarly under-inclusive with respect to excluded action and potential liabilities. Basing fines on revenues of turnovers as in Europe is arbitrary and has no relationship to the cost of the violation. So disgorgement of who got gained strikes me as a better way to think about it. Okay. So when it comes to designing injunctive remedies, and the world in which we have greater monetary remedies available to enforcement authorities and plaintiffs, maybe one of the takeaways, we should have less confidence in the ability of lawyers and courts to design remedies that specify specific steps that the defendant must take to the information asymmetry. So we should instead specify outcomes. For example, enable non-Microsoft servers to interact with the client machines in a way sufficient to receive metrics they reach. That might be the remedy, one paragraph. And then use computational devices to assess that. And if they don't get there, fine the heck out of them. On the ground that what we want to do is link the decree to the competitive harm and create incentives for the defendant to use its superior information to take and to design and to conceptualize the remedial steps necessary to achieve that result. And the technical experts working with the monitor can focus on the outcome and that not so much on the means for that end. In other words, I guess what I'm saying, and the author suggests this as well, but it's jumped out at me let's say as a lawyer who maybe was a little less fascinated by the technical details than most of the readers perhaps of the paper, is papers like this of experiences regarding compliance with restorative remedies might help us not just improve compliance with remedies, but also reverse engineer our way to designing more effective remedies in the future. Good paper. Thanks for provoking that thinking. My thoughts.
Thank you.
Ron, would you like to take a few minutes to respond to Doug's comments?
No, I think he's spot on. I think that we can do exactly that. I think by looking at these remedies, looking at the outcome from what we did, I think I certainly learned a lot. And I know that the people who were involved in writing the final judgments, and particularly the sections about the technical committee and the various restrictions and requirements, they learned a lot. And we've talked, and Jay Himes, I think, would talk if he was here, about the fact that when he wrote, when he was involved in writing the final judgments, he couldn't predict what would happen, 6 years down the line, and it was only supposed to be a year and a half. So, I think it's important to be able to take what happened and think about that in the future. And maybe that's already being done when these remedies are being written. Try to future-proof them as best we can. Although in technology, it's really difficult. I didn't know if there's a specific question. There was a lot there. So if you have a specific question, maybe you want to repeat it, and I can see if I can answer it.
I think we can turn to Q&A at this point. We have one question that came through in the Q&A for Ron. Based on your experience with the Windows operating system platform, do you think that there could be a standardized regulation for all operating systems, for example, Windows, Android OS, and Apple OS? And I guess relatedly, who is better to do this regulation? Should it be the private or the public sector?
Right. So to me, as a technologist, I'm not an antitrust lawyer. So the most important thing to me is innovation. So, technology companies need to be able to innovate. I tend to believe that, regulation isn't always the best thing for innovation. So, unless you have a company that is stifling innovation and you need to act, I don't think that operating systems should be standardized, because I think if that happened, for example, Android OS wouldn't be where it is today as the worldwide leader in mobile operating systems. I think Mac OS wouldn't have a lot of the innovation it has. Linux wouldn't have a lot of the innovation that it has. So I think I'm not a big proponent of regulation unless there's really highly anti-competitive stuff going on that is actively stifling innovation. I think I also noticed a question in the chat.
Yeah, we have a few additional questions in the chat that relate to generally the standards for Microsoft to be found compliant or non-compliant. Do you want to expand upon that somewhat?
Yeah, for us, we weren't lawyers. We're technologists, so we used the final judgments as our Bibles, so to speak. And we were just making sure that they complied with everything in Section 3. I only talked about 2 subsections here today, but there were others. I personally did things like visit Microsoft partners and competitors and solicited complaints, and that's one of the other sections that I had to deal with. But that we were very specific in our task, and we reported back to the plaintiffs, which was the United States of America and I think 19 states, and told them what we found. And sometimes if we had found anything that we didn't think was compliant or might not be compliant, we would talk to Microsoft, and they'd have the opportunity to fix it before we would talk to the plaintiffs. So sometimes we didn't have to do that. So so we didn't verify compliance, quote unquote, but our computational tools and our resources, we verified whether or not they were complying with the elements of Section 3.
Two questions, Ron. And I know you adverted to this in indirect ways in the paper. Maybe you don't want to answer it directly now. But was it your impression that Microsoft was simply trying to do whatever it damn well had to do to somehow get out from under the wrath of the judge, or was it actually trying to make the decree work?
I'm just thinking about what I mean. I don't think I have the ability to answer that. I don't. Obviously, I'm not in their mind. They certainly did a lot of hard work, and they did say, and I think we mentioned this in the paper, that they didn't realize how useful this documentation from Section 3E would be. It ended up helping them very, very much as a company, because a lot of these communications protocols hadn't been documented well in the past, and my opinion is it reduced bugs in the operating system because they had the documentation for themselves to which they could refer, in addition to competitors.
We have another question that came in through Q&A. The anonymous attendee writes, writing the interfaces to connect to Microsoft's platform was a cool way to prove their documentation. Did Microsoft not provide test cases, test results, and proof of results for proving their platform is open? And do you feel that you actually did the test work that Microsoft should have been doing to prove that their products met the requirements of openness?
So requirements of openness is an interesting phrase to use here because they, obviously Windows is not an open system, right? And these particular protocols were proprietary. They were not open source, right? So, in terms of the judgment, we would not have looked at any of Microsoft's test cases because, by definition, we couldn't trust them, right? Not because they were bad or anything, but our job was to do this independently. So we had to create our own test cases. My opinion as to whether they should have done that themselves, I don't think they needed to because there was never, prior to these judgments, there was no need for it to work, the Windows Server elements to work with anything other than Windows clients for most of the protocols.
So that's actually all the time we have for Q&A at this point, but I was hoping that both you, Ron and Doug, had maybe some closing remarks or thoughts that you wanted to share with the group before we wrap up.
Yeah, I'll just say briefly, I think it's a really exciting time for computational antitrust. I mean, as I said in my final slide, this is, we're in a time where every company has a highly technical component to them, even if they don't consider it highly technical. Everybody's online. All of these remedies necessarily will have something to do with their, well, I shouldn't say all of them, but many of them will have to do with their online presence that can be, deterministically measured using computational algorithms. So, I'm excited for the field and excited for what comes next.
Let me echo that in a slightly different way. Computational antitrust is a pretty fancy, in some ways intimidating term. To me, the real wisdom in it is the realization that we now have tools, and you said, Ron, not just for the technology industry, tools that enable us to do what we should have been doing, but have found so difficult to do for decades, which is actually to evaluate how the law interacts with the economy at various stages, and therefore presumably they can improve.
Great. Thank you so much to you both. And I'll turn the floor back to Thibaut.
Yes, thank you very much, Ron and Doug. It has been a fascinating discussion. And I think what we've seen today is that there is not a balance, but there are potentially two objectives for computational antitrust. One might be to change it all, which is kind of what we heard with the first discussion using computational tools. The second one might be to take the rules such as they exist and to improve them. And indeed, as you just mentioned, Doug, and this was part of your presentation, Ron, to just do it better, right? Do what we do, but in a way which is accessible and without the cost going through the roof. And